It is.
Yes, the Leader of the Opposition.
Thank you, Mr Deputy President. I lead for the opposition on the Criminal Legislation Amendment Child Sexual Abuse Bill. The opposition does not oppose the bill. Many of the provisions in this legislation emerge from recommendations of the Royal Commission into institutional responses to child sexual abuse. Others emerge from the Joint Select Committee on Sentencing of Child Sexual Assault Offenders and the Child Sexual Offences Review, which was recommended by the Joint Select Committee. There are a number of specific offences introduced or amended by the bill, and there are broader changes both as to offences and to sentencing. The bill introduces a new provision, Section 316 A of the Crimes Act, which is described as a concealment offence. There is already a concealment offence in legislation, specifically Section 316 of the Crimes Act. This has been the subject of previous controversy, with some arguing that the moral obligation to report wrongdoing by someone else should not be translated into criminal liability. It has been the subject of inquiries by the Law Reform Commission, with some arguing against the existence of the offence. Section 316 provides that it is a criminal offence to not report a serious indictable offence. That can clearly already include those forms of child abuse that are a serious indictable offence. The recent conviction of Bishop Wilson from Adelaide concerning events in the Hunter is an example of that section being used effectively. On the face of it, this applies to the confessional. That is, there is already a law that would breach the seal of the confessional in this state. It never seems to have been used that way, but the section requires that the prosecution prove that the defendant knows or believes that an offence has been committed. As the attorney indicated in his second reading speech, that is a high standard to achieve. An alternate offence is now provided in this bill in Section 316 A. It is restricted only to child abuse offences, in contrast to Section 316, which has no similar limitation, although it is limited to serious indictable offences. Section 316 A, however, is not restricted to serious indictable offences. Child abuse offences are defined for the purposes of this section in subsection 9 of 316 A proposed, which also includes a schedule of offences. Clearly, concealment of some of those offences would not have been caught by the existing provision 316. 316 A requires less to be proved than 316. It will apply where a person knows, believes, or reasonably ought to know that a child abuse offence has been committed. This imposes an objective standard which will avoid willful blindness. It means actual knowledge doesn't necessarily have to be proved. There is a defence of reasonable excuse, of which a non-exhaustive list is provided in the section. 316 A removes child sex abuse concealment offences entirely from 316. 316A retains the requirement for prior consent. 316A, of course, now has been amended to no longer require the prior consent of the Attorney-General for prosecution of various professions, including the clergy. In any case, even prior to the amendment by the Attorney adopted in the other place, as a matter of practicality, the Attorney's fiat had been delegated to the Director of Public Prosecutions. So while there may not be a significant practical change, there is a significant legal change in that the office which has carriage of serious matters anyway will be in the driver's seat for approval of prosecution of the clergy and other professions under 316 A. And this is a very significant change in the law, one which on this side of the House we welcome the government adopting, and we think significantly improves the law and its operation and provides more comfort in the wider community that the law will be applied to the fullest extent in this most difficult area of both the law and public policy. The penalty is the same as for Section 316, 2 years maximum imprisonment or 5 years where a person solicits or accepts a benefit in exchange for not reporting. The offence is not retrospective. Given the reports of declining number of clergy and declining numbers of people attending confessions or reconciliations, as I believe they're now called, there is a practical issue as to how often it would actually be used to break the seal of the confessional. Nevertheless, it is a significant development in the law, And as we have seen in the prosecution and conviction of Bishop Wilson, the existing law anyway did provide for breaching the confessional when necessary in important cases. So this change, I think, reinforces that aspect of the law which some people thought wasn't there and may not have been a regular feature of the law's application. Another new offence, also recommended by the Royal Commission, is in Section 43 B of the Crimes Act, shortly described as a failure to reduce or remove the risk of a child becoming the victim of child abuse. This offence applies only to adults. They must work as an employee, contractor, volunteer or otherwise for an organisation that engaged in child-related work. The offence will occur if the person knows another adult who works in the organisation with children poses a serious risk of physically or sexually abusing a child under the care, authority or supervision of the organisation. The risk will need to exist at the time it is apparent to the person, and the person will also need to have the power to reduce or to remove the risk because of their position in the organisation. For the offence to be proven, the person must be criminally negligent in their failure to remove or reduce the risk. The organisations referred to in the section are those with employees, volunteers or contractors doing child-related work within the Child Protection Working with Children Act. The maximum penalty is 2 years imprisonment. The offence will not be retrospective. Item 20 of Schedule 1 omits the current offence of Section 66 A of persistent sexual abuse of a child. That offence was only introduced in 1999. It was an attempt to deal with persistent cases of abuse where it was difficult for victims to distinguish individual incidents and provide particulars of each occasion or incident. Requiring that to be done in a prosecution would mean, quite perversely, it would be easier to prosecute in a circumstance where there was only one discrete assault rather than a large number of persistent assaults over time, which of course would be an outcome that none of us in this place or in the wider community would want, accept or tolerate in the law. The Royal Commission recommended the adoption of an offence based on the Queensland model for this type of circumstance. I understand this model has also been adopted in South Australia. The Attorney's second reading speech, and that given by the Minister in this chamber, says this bill now adopts that model. The light's not on, but the microphone is. Section 66EA will now criminalise the maintaining of an unlawful sexual relationship with a child under 16 years of age. 66EA2 defines an unlawful sexual relationship as one in which an adult engages in 2 or more unlawful sexual acts with or towards a child over any period. Unlawful sexual acts are defined in 66EA15 by reference to existing offences. They extend, for example, to an act of indecency with a female under 16 years. 66EA4 provides the prosecution does not have to allege the particulars normally required for a prosecution, but is required to allege the particulars of the period of time over which the relationship existed or is said to exist. 66EA5 says that the jury must be satisfied that the unlawful sexual relationship existed, but is not required to be satisfied of the particulars of any unlawful sexual act, nor are members of the jury required to agree on which unlawful sexual acts constitute the unlawful sexual relationship. If the jury is not satisfied that the offence under this section is proven, but is satisfied of a particular fact, then the defendant may be convicted in relation to that incident. The maximum penalty for the offence is life imprisonment. Proceedings can only be instituted with the approval of the DPP. The aim of that is to ensure, according to the second reading speech given by the Attorney and the Minister in this place, that it is only used where the victim cannot give sufficient particulars to charge individual offences. The offence will apply retrospectively. The New South Wales Bar Association has raised concerns with the opposition about this provision and have referred to their major concern regarding the proper administration of justice. To quote from their briefing note, this new offence with a maximum penalty of life imprisonment raises the following concerns. 1. It does not require a jury to agree as to the nature of the sexual acts involved in order to convict an individual. 2. It does not recognise the range of sexual acts that can occur at different levels of criminality and attracting penalties proportionate to the actual crime. 3. It creates significant difficulties for a sentencing court and a real risk that the sentence imposed will be much more severe than justified by the verdict of the jury. The Bar Association points to the Victorian example of Clause 4A in Schedule 1 of the Criminal Procedure Act 2009, and they argue that, and I quote, "The Victorian provision avoids the seriously problematic aspects of the new Section 66EA. It avoids any potential breach of the principle that a sentencing court should sentence in accordance with the jury's findings with respect to the elements of the offence. It overcomes the difficulties with particularising specific sexual incidents where there is continuing sexual abuse without creating the potential for real injustice that arises from the new Section 66EA," unquote. Now, the Shadow Attorney in the other place asked the Attorney to respond to those concerns, and the Attorney-General did do so. And I won't seek to repeat here what the Attorney said. That'll be clearly available on Hansard. But we are not persuaded that the concerns raised by the Bar Association are such that the provisions of the bill before the House should be amended in that regard, and so we accept this aspect of the bill as it stands. There are also changes to grooming laws. A new offence criminalises grooming a person, normally a parent or a carer, with the intent of procuring a child under 16 under the care of that person for unlawful sexual activity. This requires the offender to prove a financial or other material benefit to that adult. Proceedings can only be instituted with the approval, again, of the Director of Public Prosecutions. The existing offence of grooming a child under 16 in Section 66EB is broadened to include providing a financial or material benefit to the child. The provisions of Section 73, headed Sexual Intercourse with Child between 16 and 18 under special care, are amended, and a new offence is included in Section 73A, so that the behaviour criminalised extends beyond intercourse to sexual touching. Recommendation 1 of the Joint Select Committee sentencing on child sexual assault offenders, of which the Shadow Attorney was a member, in its October 2014 report reads as follows, and I quote, "The committee recommends that the New South Wales Government reviews all offences and other provisions in New South Wales which are particularly relevant to child sexual assault offences and offenders with a review to, bullet point, consolidating and simplifying the current framework where possible so that it is more user-friendly for the legal community and victims. Bullet point, identifying areas where current offences could be consolidated or revised. Bullet point, identifying whether any new offences should be created to fill any gaps in the existing framework." Unquote. Recommendation 3 was that the review be carried out and finalised as a matter of high priority. Approximately 4 years later, the consequences of those recommendations are at least in part implemented. This involves the reorganisation of Division 10 of the Crimes Act together with modernising and reordering amendments. Additionally, the language of indecency is now replaced by sexual touching and sexual act, which is a sensible change, and people will have a much better idea of what a charge actually means if those new labels are applied. Sexual touching is intended to mean contact offences involving some form of physical contact with the victim. Sexual acts mean offences that don't involve contact with the victim but involve sexual conduct. The sexual act offence penalties are the same as is currently the case for indecency offences. Penalties for sexual touching are the same as is currently the case for indecent assault, but there is a new offence of sexual touching a child under 10 with a maximum penalty of 16 years and a standard non-parole period of 8 years. Schedule 2 to the bill has an important provision amending the Child Protection (Offenders Registration) Act in relation to the Child Protection Register. A new Section 3C provides a discretion to a court to, in some circumstances, treat a child offender as non-registerable, that is, not to list them on the Child Protection Register. The circumstances in which the discretion can be exercised are if the victim was under 18 years of age, where the child has not previously been convicted of a Class 1 or 2 offence, where full-time detention or an operative control order are not imposed, and the court is satisfied that the person does not pose a risk to the lives or to the sexual safety of children. There are other important provisions concerning the practice known as sexting. The provisions seem a sensible attempt by this Parliament to come to terms with behaviour, which, depending where you are in the generational scale of things, may be regarded as perhaps hard to understand, but which certainly shouldn't be criminalised. New section 91HA9 provides it is a defence to a charge of possessing child abuse material if the only person depicted in the material is the accused person. Subsection 10 provides a defence to the charge of producing or disseminating child abuse material if the person produced or disseminated material when under 18 and if the only person depicted was the accused. A new section 91 A provides that a person is not guilty of possessing child abuse of material if the possession occurred when under 18 years and a reasonable person would consider the possession of the material as acceptable, having regard to a number of factors. One of these factors is the relationship between the accused and the child depicted. The use of a reasonable person and acceptability obviously create a degree of uncertainty, but given the complexity of the issue, that rather follows, rather than there being any failure in the drafting or the intellectual rigour behind the provision itself. I think these are useful provisions which should avoid the potential for young people to run the risk of being unnecessarily criminalised. So it's quite a sophisticated and nuanced approach to the drafting and the substance of these offences. Another provision relating to children and young people is item 46 of Schedule 1, which among other things provides a new defence in section 80 G. It is a defence to the prosecution of various sexual offences against a child between 10 and 16 years if the victim is of or is above 14 years of age and the age difference between the alleged victim and the accused is no more than 2 years. The heading of the section is defence of similar age. Whatever you might want to say about such behaviours, it is hard to see why it should be in the purview of the criminal law. And again, this is another attempt in the drafting and the thinking behind the provision to criminalise that which should be criminal and to try and treat other behaviours as not being criminal where, on a fair analysis, it is not warranted. Always a difficult balancing act, Mr Deputy President, in this difficult area. Schedule 3 amends the Crime Sentencing Procedure Act. One amendment provides that in relation to historical child sexual abuse, a court, when sentencing an offender, cannot regard good character or behaviour as a mitigating factor if that was of assistance in the commission of the offence. And that's quite important because so often in child abuse situations, offenders are able to access the victims and trade upon their trusted position. And that should not also, upon conviction, not be able to be prayed in aid or used in aid on sentencing if in fact that was the same currency, as it were, used to commit the offence. This presently is the case for current offences, but it extends it to historical offences as well. A new section 25 A provides that an offender must be dealt with by the court in accordance with the sentencing patterns and practices at the time of sentencing in relation to child sexual offences. The current common law provision in this state is that the court should be guided by sentencing patterns that were in place at the time of the offence. To do otherwise has been historically argued as is a form of retrospectivity and thus bad in principle. In practical terms, in relation to these offences, previous sentencing patterns were less severe than is presently the case. The objection in principle is met by three, I think, quite powerful arguments. The first is that it relates to child sexual offences and not more broadly, which should take should be pursued with very heavy moral opprobrium. The second is that the earlier and more lenient sentencing patterns were not the result of some carefully thought out and sensibly calibrated analysis or principles of law, but rather resulted from attitudes that failed to recognise, or perhaps, given what we now know, refused to accept the seriousness of the offences that have occurred historically. Third, as the attorney pointed out in his second reading speech, the maximum penalty for the offence will remain what it was at the time of the offence. So the substantive law will remain unchanged, but the sentencing approaches and principles will be as at the point of conviction. This, as I understand it, is the model adopted in England. The standard non-parole period, if any, is also that applicable at the time of the offence rather than that at sentencing. The bill will also deal with what was Section 78 of the Crimes Act. There was a limitation period that meant that various sexual offences against some children had to have prosecutions commenced within 12 months of the offence. The limitation period was abolished in 1992, but the abolition was not made retrospective. This bill will make that abolition retrospective, which means that these types of historical offences committed prior to 1992 can now be prosecuted if the evidence is available. The Criminal Procedure Act is amended to provide for a new type of jury direction to allow the provision of educative material. A new section 80, capital A, capital F, has a procedural provision to deal with complexities in offences occurring over a period of time. With those comments, the opposition makes clear we do not oppose the legislation. We see much that is good in it. We hope some of the difficulties that have been identified are worked out over the implementation of the new legislation. But of course, the opposition, like the government, like every party, will remain vigilant in this important area of public policy and law.
So what I'm going to do is this.